Good morning to all of you. Welcome to Legal Minds by Sai Babu Sunkara. Our topic for today is regarding surrogacy. You may be knowing about surrogacy. Surrogacy is nothing but IVF model of delivery of a baby boy. Even though the mother delivers, but she will not have any rights. So the semen of the person who has donated, he will be having the control, or he will be called as the biological father. So you may be knowing there is a surrogacy regulation bill. Surrogacy regulation bill was actually it was supposed to be passed in 2019, but so far the bill has not seen the light of the day, and it has not been promulgated as an act. I think very recently it was proposed in the parliament. It may come out as an act very soon. Now, a district judge cadre, Chitramsh Arora of Saket courts, she has clearly stated that there is no law barring the parties from entering into gestational agreements or gestational contracts. So you must know what is a gestational. In Telugu I call Garbhadharana. So who has to bear the so-called pregnancy, that this is what is called a gestational agreement, right? So here everything is okay. Only thing is to get a suit for declaration, that's all. There is no dispute also in this particular case. Now, since I should not tell the names and others details because of the surrogacy, so we will hear, or you will hear the case like this. So there is a couple who are in need of money, or who wanted to, out of whom the wife wants to bear the pregnancy. They have come forward. These are the plaintiffs. The defendants, yes, they are having no children, so they want to have children. They want to have the children by means of surrogacy or IVF system, right? Both of them entered into agreement. So the defendants wanted to give some money to the plaintiff because of their needs, and ultimately they wanted to get the woman bear the child. Everything is accepted. Now it is called a gestational agreement, gestational surrogacy agreement between the parties. The plaintiff here, okay, you will refer the plaintiff as the person who actually wanted the child, and the defendant as the woman who wanted to bear the pregnancy, who took money. So let us better give in the direction, right? So now, as agreed, the defendant, so the semen was sent into the womb of the so-called defendant. Yes, she bore the baby for about 9 or 10 months. Ultimately, she gave delivery. So due to this, a baby girl was delivered, and later the baby girl was handed over to the plaintiffs. No problem. They have taken the money and handed over also. Now, the plaintiff couple, they have got an apprehension, but that after some days, the defendant may claim the guardianship or parentalship, may claim a dispute regarding that. So in order to avoid all these future consequences, now the plaintiff party, they approached the court, Saket court, for suit declaration of the suit, and injunction to be given in their favor. So now the suit is taken on file. The other party, that is defendant party who gave birth to the child, they also came. They said there is no objection. So that means they have admitted regarding the gestational surrogacy agreement. So now the CPC, Order 12, Rule 6 of the CPC comes into existence. Order 12 deals with the admissions. Here the defendants have admitted that they have entered into a gestational surrogacy agreement with the plaintiff couple to give birth to the child. Yes, as agreed upon, she has given birth to the child, and they don't want any claim over the baby. No dispute. So therefore, please remember, when it is admitted, Order 12 regarding Order 12 Rule 6 says judgment on admissions. So if there is any admission, if orally or in agreement or in writing if admission is there, the court need not proceed further and they can give judgment basing on the admission itself. Therefore, Order 12 Rule 6, basing on Order 12 Rule 6, Chitramshi Arora, she gave the judgment holding that the couple who gave the money to the defendant, they are held to be the biological parents of the baby girl, and the court restrained the defendant couple from entertaining or from acting in contravention of the gestational surrogacy agreement. So please remember, here there is no law, so far there is no law regarding or barring the gestational surrogacy agreements. Of course, here the judge has also given a caution, but these persons should follow the directions or guidelines given by the ICMR, Indian Council of Medical Research, regarding surrogacy arrangements in India. So since the act is not there, these problems are coming. Anyway, let us hope that the act will come in force immediately, so that this surrogacy process, no doubt people want children by any means, by IVF or by surrogacy or by test tube method, all these things are there, but they should be regulated. Otherwise, same here, they have thought of the future. Suppose if they have taken the baby girl and on some day the defendant filed a case against the plaintiff stating that she has given birth to the child and therefore the custody of the child lies with her, then what happens? So thinking all these things, they have filed a civil suit under section 26 of the CPC, and the judge also reacted in a positive way and gave the judgment. Very good judgment. Since the Surrogacy Act now has not come in force, you have to depend on such judge-made law only. So please read the judgment and enrich your legal knowledge. Thank you very much.